Okay, everyone, thank you for joining us at today's Planning, Economic Development, and Land Use Committee meeting. On the agenda, we have two items, Ordinance 61.111.25 and Ordinance 16.82.25. We did have one that we removed from the agenda as some more information is coming in. That is the historical tutors. That's been removed from the agenda, but I do appreciate the work that's being done behind the scenes. I had a good walk today with the owners and the Historic Association on the sites, and I appreciate the owners being willing to do that and their openness to that. So I just wanted to make that comment publicly, but that is not on the agenda for today as of now. So can I get staff to do roll call, please? Roll call? Yes, roll call.
So currently present, we do have City Clerk Shaniqua Jackson, as well as Legislative Director Brian Jimenez, as well as myself, Junior Legislative Aide Carly Johnson, as well as Committee Chair Alfredo Ballerin. Now we have Thomas Hoey, as well as Sergio Adams and Deborah Zamer. With us as well, we do have Brad Glass, as well as Avi Epstein, to present this evening from the Planning Board.
Okay, thank you very much. And we're going to start with Ordinance 61.111.25.
All right, good evening. So this is the ordinance for changes to the parking lots within the MUFM zoning district. There we go. So this request and amendment really stems from a request by the North American Islamic Trust, who has a mosque and facility on Central Ave that also abuts the back of Bradford. That's highlighted on the map in yellow. They want to use 7 vacant parcels highlighted in red on the map for a ancillary parking for that use. However, it's located in a MUFM district, which only allows parking as accessory, meaning the primary use would have to be on the same lot, and in this case it is not. So just as an example, for this property, this is 128 through 140 Bradford Street. Here we're just looking at the vacant lots on the street. Currently it's kind of being used informally as parking. The applicant has been working on some concept ideas of what this would look like to, in the end look like a parking lot and provide pedestrian and vehicular access to the site. Currently, and as proposed, the changes would include, right now if you look at the column that's highlighted, the MUFM zoning district only allows parking, surface parking lots as an accessory use, so it prohibits the use of a parking lot as the principal use in the zoning district. What we'd be proposing here would be changing that to a conditional use permit. This would be similar to how it's done in the MUCU zoning district, which was amended to include similar provisions in 2021. So this amendment would allow surface parking lots to be a principal use in the MUFM district. Just for reference, the map on the right, in red, you see the areas that are located within the MUFM district. It would require a conditional use permit before the planning board. It would apply the same standards for review that were applied to the MUCU district. And it ensures that any new lots have to be updated to meet the use-specific standards, design requirements, and other parking-related provisions within the code. Specifically, there are a set of review standards that the planning board would have to review for this type of conditional use permit. It would have to be meeting a demonstrated need, that the parking is clearly serving nearby properties, supported by various evidence. Proximity, so it has to be, the lot itself would have to be within 300 feet of the property or the main property that it serves. Vacancy or underutilization of the sites, so the site would have to be vacant or underutilized for at least 5 years with no near-term development prospects. For future redevelopment, for deeper lots, typically about 100 feet in depth, the layout has to preserve the option for future buildings along the street frontage. And then no demolition for viable structures, meaning if there is a building that has the potential for economically viable use or reuse, demolishing that building for a parking lot would not meet the criteria or the standard here. So in summary, the ordinance would be allowing for parking lots to be a principal use in the MUFM zoning district. They'd be subject to a conditional use permit. It would remove the requirement that it's just accessory as of right now, and it would make sure that it applies the use-specific standards currently in the code, which are being as drafted. The standards would remain the same, but there's a few points of clarification that we're adding to it. And then this would be aligning the MUFM with the changes that were made in 2021 to the MUCU district. The ordinance supports nearby institutions, businesses, while maintaining long-term mixed-use goals of the district. That, I'll just pause if there's any questions.
Questions from committee members? Committee member Zama.
Thank you. My question is, were that vacant area, those were houses? Was that from, that were lost?
Lost due to a fire 5 or 6 years ago.
So the proposal for the trust to purchase that area,
Mm-hmm.
and then it'll be taxable as a parking lot?
Yep. Yeah, I believe they already have ownership of those. So
Oh, they do?
essentially they'd be consolidating them and turning it into parking. However, right now it can't be used as parking under the way the code's written.
Okay, they already own it, you said?
They already own it.
Oh, okay, thank you.
Councilmember Hoey?
Thank you, thank you. Are they paying taxes on those parcels now, or are they tax exempt because it's a religious institution?
I'm not sure, but I have to check. Yeah, I don't know offhand. I think as separate parcels right now, I think they might be classified differently from like the tax assessment. I don't think they're under the same category as the mosque itself.
Any other questions by committee members? So just a little background on this. I remember when the fire occurred, I think it was like 2019, and it was a really bad time because luckily everybody got out safely. But people lost everything they had. And the community really came together, and the mosque came together to really help everyone on that block that lost something. Not just members of the community, but just everyone that had lost everything they had in those fires. So I'm glad that they're able to repurpose it, if possible, to something that will hopefully ease some of the traffic that we've seen on the front of the mosque, with parking issues, as well as with just a lot of people during prayer hours, especially during Ramadan and other holidays. So hopefully this helps ease some of those issues that they've had in the past. Any other questions from committee members? Okay. If not, then do I get a motion to move out of committee with a favorable recommendation, ordinance 61-111-25.
I'd like to make a motion that we move ordinance 61-111.25 out of committee with a positive recommendation.
Do I have a second?
Second.
It's first made by Councilmember Adams, seconded by Councilwoman Zamer. All in favor?
Aye.
Aye. So that is unanimous. Anyone against? No? Okay, unanimous. Okay, so that's passed. Next, we have ordinance 16-82-25.
Okay, so ordinance 168225 proposes changes to the way the process for making a determination of nonconforming use works. When we talk about a nonconformity, we're essentially talking about something that's grandfathered. So let's say a 3-unit building that's in a 2-family zoning district. So typically what we're doing in this case is we're getting an application and we're trying to prove that the use that predates the zoning that's currently in effect and therefore is allowed to exist there. When we redid the zoning in 2017, we eliminated a lot of non-conforming uses overall. But given that we're an old city where some of the city, a large part of the city was developed pre-zoning, or we may have different priorities moving forward, there are a lot of properties that are still non-conforming. And I think the goal is for them to go away gradually over time, not necessarily overnight. In this case, an application is submitted. We're reviewing records in our office. When we go through our records, we have I'd say about 90% of the applications that come in. We're very easily able to document when that use came into effect and when the zoning prohibited it. So we can clearly see whether that's before or after the zoning when that use was there and located. The other 10%, usually those are illegal uses or something to that effect that we can't document, and that's when we really get into the applicant requesting their evidence in terms of supporting the nonconformity determination. Just an example of some of the documents that we use: zoning ordinances, zoning maps, the Polk City directories. They list businesses and number of residents, names of residences at particular properties, and we have those dating back to the 1920s pretty consistently, and in some cases we have them from the 1800s. So we have a pretty good account of how many people lived at an address at a given time. We also have modern records like ROPs to know how many units are allowable within a structure. An example here is a building at 37 to 39 North Manning Boulevard. It's located in an R2 zone. So in an R2 zone, you can only have one principal structure in a lot, and you can only have a maximum of a 2-unit dwelling. So in this case, you have two 2-unit dwellings that are attached to each other. So the use itself is allowed, but you're only allowed to have that one structure, and these are two separate attached townhouse structures. So technically, in the R2 zone, this would be a non-conforming property. Oftentimes, when someone's going to sell a property or a property's changing hands, the bank wants to see that that use complies with the zoning. In a case where, for example, something like this is non-conforming, they're going to be particularly attentive to that, and that's where we get out of a basic zoning letter to something that's looking at justifying something that's grandfathered. Another example here is the Levine Funeral Home. It's located in an R2 district. Once upon a time, there was a C1 commercial zoning district there. In the current R2 district, for buildings such as this that were built for another purpose, there are certain allowances for other commercial uses, not necessarily funeral homes. So in this case, that use is allowed to continue until such time it vacates the premises and a new use comes in there. In this case, I believe the ownership was changing hands. They were requesting a letter, so they needed to get a nonconformity determination because under the current R2 zoning, a funeral home is not an allowed use there. So to go through the process here, I should have probably introduced it earlier, but a zoning compliance certificate is sort of a generalized letter that typically a bank or an attorney involved with the sale will request. And, it may request, so I have a 2-family house. Is this legal at this address? So we'll check the zoning, and if it's an R2 district, well, yes, clearly that's a 2-family district. That's allowed there. We would issue the letter. However, if, for instance, they say we have a 3-family house that's in a 2-family district, we have to say, sorry, that's not allowed there, but you can apply for this determination that this is a legal grandfathered use. So at that point, they would make that application. They'd request the status determination. Like I said, pretty early on in that process, staff is going to know. It does allow them to provide evidence, as outlined in the code, to support their case. The onus is on the applicant or the property owner at the end of the day to provide evidence supporting the nonconforming use. But we typically, as a service, provide that to some degree because it's readily accessible to us, And it can be very difficult for someone in that position to have to go research at the Hall of Records or find some of these records otherwise. So that is a secondary step. Typically, that was all, used to be one step under our zoning compliance process. At that point, we would just write the letter saying, yes, this use is not a legal use in this zoning district. However, it is a legally non-conforming use due to these circumstances. However, under the current code, it speaks to public noticing being required. So at that point, before we can make a determination, we have to provide the applicant with public noticing materials to post the property and to send a mailing to property owners within 250 feet. And then once that is, we have proof that that has happened, we need to wait an additional 14 days before our office can make a decision on the matter. So in addition to the confusion that sometimes this can create, it's adding an additional 30 days to a process that when a sale is in place, that's often delaying a sale. We have seen a number of them that never go through that process, so there's a question of whether the sale even goes through at that point. You know, and when we're looking to see properties, you know, recycled and reused, this can be a deterrent to a property sale or a property investment. This is just an overall map of, these are all the zoning compliances requests and where they're concentrated, a lot of them in the more urban neighborhoods of the city, although we get them all over. These are the standard requests, and then these are the ones that go through that DSN process. Again, we have 23 of them, as compared to 1,200 zoning compliance certificates, so not a huge amount. Although I think, I don't know if we had an exact number, but Avi was looking into it, there were another 80 or so that just never went through that DSN process, so we don't know what happened with those, if the sale fell through, if they were able to exchange the property regardless of having that letter, or how exactly that panned out. But during that time, the 23 that we did pursue the process, we received a total of 6 letters in response from the property owners that were mailed. It's about a 0.5% response rate, and I will say from the ones that I've seen, it typically was more of a letter of, yeah, I don't want to see that use at that property, so I don't want to see a 3-family in a 2-family district. But the reality of it is that's not really what we're looking at. We're looking at whether that 3-family predates the zoning and therefore has a legal right to exist. So I think to the extent that people were responsive, they were misunderstanding the content of the letter. And I don't know that we've ever got any direct evidence from a property owner, adjacent property owner, or a member of the public speaking to, well, I know this property, it's been like this, here's evidence that, you know, in this year, it actually wasn't that use, and this shouldn't be approved. That's not to say that that isn't out there and there aren't really helpful circumstances of that, that just hasn't been the response that we've received over that period of time. So again, the average time to review a DSN is 30 days. I would say, apart from that delay, there's a lot of consternation between the party that's trying to sell the property, the party that's trying to buy the property, none of whom can understand why they have 3 ROPs and this property is taxed as a 3-family and it's documented, why we can't simply provide them with a letter saying that, why we have to go through this particular process. And I think just given the lack of return on, you know, the amount of notices that are sent out in these circumstances, and, you know, the fact that we're not getting a lot of feedback, and the feedback we are getting are in circumstances where we already have the evidence to support the determination one way or the other. So we're looking to make an adjustment here to not require that noticing requirement and go back to the prior proposal, which essentially you have one zoning compliance determination process. If it's a non-conformity, we essentially speak to that as a secondary matter in the letter, and it doesn't require that notice and delay to the process. I think that covers it for the most part, but happy to answer questions.
Questions from committee members? Okay, no questions? Anyone have questions? Okay. So just to be clear, this is going to make it easier for people to sell their properties if, you know, they've got a property that has been something for years, but with the rezoning, it may have come out of zone, correct?
Correct.
Because I remember the Levine Funeral Home issue. So, okay, sounds good. Thank you. Any other questions or comments by committee members? No? Okay, well, if there's none, can I get a motion to move out of committee with a positive recommendation, ordinance 168225?
I'll move ordinance 168225 out of committee with a positive recommendation.
Second.
Okay, motion made by Councilwoman Zamer, seconded by Councilmember Hoey. All in favor?
Aye.
Aye. Okay, so that is, passes unanimous consent. Okay, at this point, is there any other business by the body? If not, I ask for a motion to adjourn.
Motion to adjourn?
Is there a second?
Second.
All in favor?
Aye.
Aye. Okay, excellent. All in favor? Our meeting is adjourned. Thank you, everybody, for taking your time out today, and get home safe.